Constitutional Court has ruled that only Sishen Iron Ore Company, which is a subsidiary of Kumba, may apply for the rights to 21.4% of its Sishen mine in the Northern Cape. Those rights once belonged to ArcelorMittal. Robert Lee, who's a partner at Bowman Gilfillan, has come in to help us understand this very complicated court action, which began when the Guptas decided they could grab themselves a little slice of a very big iron ore mine. Well, they've been put to the sword, but why has it taken so long, Robert?
Alec, litigation is complex, and these are very complicated issues that have been teased out through the courts. I mean, the fact is that ICT trading actually has lost 3 times around in this, together with the Department of Mineral Regulation. But the MPRDA is a complex piece of legislation, and what this does do, I think it provides quite a lot of certainty, which has been lacking. The DMR has kind of taken a sort of a discretionary approach to the allocation of mining rights. What the earlier courts did is they kind of looked at it through what I would call a kind of an old-fashioned prism. And what's refreshing about this judgment is that it looks at the legislation through a new constitutional prism, but in with a view that is actually rational and commercial, and I think provides some certainty to mining companies going forward.
Not just locals, but international investors too?
Absolutely. Look, this is not a panacea. It's very fact specific, and it relates to the conversion of mining rights from old order mining rights to new order mining rights, and that was a transitional phase. So it's not going to guide the DMR in terms of the allocation of new rights going forward. But there may be a whole range of other disputes relating to similar factual matrices, which can now be, may be resolved. But I think it does send quite a strong message. And if you look at the judgment of JAFTA, it makes it clear that it recognizes the sort of fundamental reformative aspect of the legislation, but at the same time saying that basically mining companies in place cannot be dislodged through some kind of administrative fiat by the DMR allocating rights to people whose sort of mining capacity is doubtful, or at all. The one note of caution that I would add is that this, I think it puts an end to the Sishen ICT dispute for once and for all, and the arrangements between Kumba and AMSA have now been sorted out in terms of their supply agreements. So I think this kind of story goes away. But there is before Parliament an amendment to the Act, which I think was drawn up as a consequence of the earlier losses sustained by the minister in the previous cases, aimed at giving the minister these kinds of discretionary rights that the court has indicated that based on the current law is not appropriate.
It's interesting.
And that's a challenge. That legislation is controversial. There's certainly question marks over its constitutionality, and there's quite a big government push to get it through. But
Robert, is there a parallel here with what Herbert Mashaba and the Free Market Foundation are trying to do in the discretion that the Labour Minister has got? They're taking that to the Constitutional Court, just with the one word. This seems to, the Constitutional Court has now ruled, perhaps discretion by politicians is not something that they'll be able to take as a right in future.
Well, I think, we live in a constitutional democracy. Ministers and officials are given discretion, but they have to exercise that discretion fairly and within a constitutional framework. In the old world, the National Party world of government, the law was often die wet is wat die minister sê. And unfortunately, It's not in our new world. And you're going to find this constant tension between government and administrators exercising discretion. And it's, administrative law challenges have become a huge part of the legal environment. But my hope is that perhaps the DMR sits back and reflects a little bit on this judgment. I think, as I said, I think it puts an end to this dispute. But this industry is crying out for certainty. And you don't need to read very far to see that our mining industry has suffered through underinvestment in the last few years because of a lack of certainty. And I think it would be there should be some careful soul searching as to what happens with this legislation, this amendment legislation presently before Parliament.
Robert, do you think this perhaps sets the tone for a turn in the tide regarding mining legislation in the country?
What the views in the DMR are on mining legislation compared to the Constitutional Court, they offer different, they're independent. The court is independent. Hopefully, there have been a few things that have happened this week that might make people in government sit up, but the mining industry cries out for some greater certainty in how these things are implemented. And when you're making 30, 50, 60-year investments, you do want some certainty as to your mining authorizations. And this is you speak to any senior mining executive, it's a challenge, and people are looking. Investors are investing their dollars elsewhere at the moment in mining.
We are a constitutional democracy, as you said earlier. We've got a fantastic constitution. Nobody anywhere in the world has probably got a better one. And I guess as a young democracy, we've got to go through these processes. People will take a chance. Politicians are people too. And this seems to be an instance of perhaps the DMR just went through all the processes to get clarity, rather than supporting the Guptas.
I can't comment on the specific politics of the particular case. There are a lot of inferences one way or another. I think what is very positive about this case is that it's actually the first time this piece of legislation has come under close scrutiny of the Constitutional Court, and have really interpreted it in a constitutional way, in a sensible way, and in a way that will provide certainty for people in the mining industry.